Hello all, welcome to Narayana IAS Academy. This is Sureka Bhaskar presenting to you the daily news analysis. So for today's discussion, we've picked up a number of articles from both the Hindu as well as the Indian Express, which are both important and relevant for the UPSC CSE examination. Now let us have a look at the topics one by one. The first article for the day has been picked up from page number 13 of the Indian Express, India's new criminal laws. So in this particular article, we'll be discussing about the new three criminal laws, that is the Bharatiya Nyaya Sanhita, that is the BNS. Next is the Bharatiya Nagrik Suraksha Sanhita as well as the Bharatiya Sakshya Adhiniyam that will actually take effect from the 1st of July, that is today 2024. And here we'll be discussing what are these three new criminal laws and why is there a need for the criminal laws in India, what are the changes that have been introduced, and also we'll be discussing about what is its significance and the associated challenges. The second article has been picked up from page number 6 of The Hindu, quote, on climate right and how India can enforce it. So in this particular article, we'll be discussing about the recent Supreme Court judgment on the climate change. That is, it actually established a constitutional right to be free from the adverse impact of climate change. And also this particular article discusses about why is there a need for a climate legislation in India. The third article for the day has been picked up from page number 8 of The Hindu, should education be brought back to the state list? So in this particular article, we'll be discussing in detail the current or the ongoing debate on moving this particular subject of education to the state list from the existing concurrent list. The fourth article has been picked up from page number 12 of the Indian Express. Government approves rupees 56 crore for the next stage of conservation plan for the Great Indian Bustard. So in this particular article, we'll be looking into how the government has actually approved this 56 crore for the conservation of the Great Indian Bustard, and for the prelims examination, this particular species in news as well as its conservation and the Supreme Court's observation and various government initiatives for the conservation becomes very, very important. The last article for the day has been picked up from page number 17 of the Indian Express, where BIS sends government debt warnings before the big global polls. So in this particular article, we'll be discussing about this particular institution or the organization of BIS that actually stands for Bank for International Settlements. And towards the end of the session, we'll be solving few prelims as well as the mains practice questions. And now let us get into the discussion. The first article that we'll be discussing today is India's new criminal laws. So as this particular title suggests, we'll be discussing the three new criminal laws, that is the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita, as well as the Bharatiya Sakshya Adhiniyam. Okay, so these three criminal laws that will actually come into effect from 1st of July 2024, that is today, and we'll be discussing about what is the need for such existence of or the prevalence of such criminal laws, what have been the changes that are actually introduced there, what are the significance of these particular laws, as well as what are the associated concerns. So in this particular article, we'll be discussing about the new criminal laws that will take its effect from today, and also India's criminal justice system, what are the loopholes and in what way these laws will actually plug the gaps. So here we can actually map this particular topic to GS paper 2, government policies and interventions, as well as Indian constitution historical underpinnings. So moving forward, there has been a question asked in 2017 in the mains examination regarding mob violence. So in this article as well, we'll be discussing where this mob violence or the provision of mob violence is actually contained in these criminal laws. So this particular topic becomes very, very important for your mains examination in specific. So moving forward, let us understand what this particular article is discussing about. Okay, so the three new criminal laws, that is the Bharatiya Nyaya Sanhita, that is the BNS, as well as the Bharatiya Nagrik Suraksha Sanhita, that is BNSS, as well as the Bharatiya Sakshya Adhiniyam, that is BSA, are taking effect from 1st of July 2024. So moving forward, let us actually understand, what are the existing criminal laws that these new laws will actually be replacing. Okay, so the Bharatiya Nyaya Sanhita, that is the BNS, will replace the IPC, that is the Indian Penal Code of 1860. So what is IPC basically? The Indian Penal Code is the official criminal code of India, which was actually drafted in the year 1860 after the first Law Commission actually came into existence in 1834 following the Charter Act of 1833. So that is what it is. So IPC is the official criminal code of India, drafted in 1860 in the wake of the first law commission, which was established in 1834 under the Charter Act of 1833. So here, now what is your, takeaway from this particular article is you must know about the first law commission and its provisions or the recommendations. Next one, we need to know about the Charter Act of 1833, as sometimes, it can be asked as a one-liner or as one of the statements under your polity section or your history section in the mains examination. Now moving on to the next criminal law, that is the Bharatiya Nagrik Suraksha Sanhita, that is BNSS, which will actually replace the Code of Criminal Procedure 1898. So what is this Code of Criminal Procedure? This provides procedures for administering criminal law in India, which was enacted first in 1973, and this actually became effective in the year 1974, and to be very specific, 1st April 1974. And the next one, if you see, the Bharatiya Sakshya Adhiniyam, that is the BSA, will replace the Evidence Act of 1872. Now, if we see what is this Indian Evidence Act of 1872, let us actually see what it is. It was originally passed in India by the Imperial Legislative Council in 1872 during the British Raj, and this actually contains a set of rules as well as allied issues governing the admissibility of the evidence in the Indian courts of law. Now moving forward, let us understand why is there a need for such replacement or the existing criminal laws in India. So first one is outdated colonial legacy. Okay, so the current laws like the IPC, the CRPC, as well as the Evidence Act, all these were actually of colonial origin, right? So they had a colonial legacy, but they are not suitable to the current changing, social norms and characteristics. So here, if you see, the current laws are based on the colonial era principles and they do not reflect the modern Indian society's realities as well as aspirations. For example, if you see Section 377 of IPC, this was the section which criminalized the same-sex relations, right? So this was actually struck down by the Supreme Court in 2018 as it actually did not align with the modern or the contemporary values of equality as well as non-discrimination. So this is one of the reasons. The second reason is the laws in India that are actually complex and ambiguous. Okay, for example, outdated, complex and ambiguous laws, they actually lead to delays, inefficiencies, and sometimes there are even injustices in the justice delivery systems. For example, if you know the Nirbhaya gang rape case, it actually took nearly 7 to 10 years to reach a final verdict. The next one is evolving nature of crime. So you can say crime is constantly evolving. Okay, earlier it just used to be murder, theft, etc. But now it is actually, with the advent of artificial intelligence as well as technology and IT, there are cyber crimes as well. But the laws have actually remained intact, and there are certain, laws which do not even have sufficient provisions for curbing such cyber crimes. Okay. Now moving forward, the next reason is there is misalignment with the constitutional values. Here, the laws are not aligned with India's constitutional values like equality, dignity, secularism, as well as human rights. For example, you can see the sedition law that is actually mentioned under section 124A of the IPC has been criticized for stifling. That is, it has been curbing the freedom of speech as well as expression. That is actually a fundamental right enshrined under the Constitution. Okay. The next one, there are a number of instances where there are human rights violation. Here, Indian criminal justice system is often accused of violating the human rights, including there is custodial torture, there is extrajudicial killings, there are false arrests as well as unfair trials. For example, if you see, there have been, custodial deaths specifically in with the state of Tamil Nadu. You can see Jairaj as well as Benik's death in Tamil Nadu under the police custody in 2020. So these are the reasons why there is a need for a change in the criminal laws, or why the current laws like the IPC and the CRPC have to be replaced. The next one, we have to understand what are the key changes that are introduced in the new criminal laws. So let us actually go through them very quickly. First one is Bharatiya IAS Sanhita. Okay. So here, new crimes have been introduced. Clause 69 of this particular BNS, it penalizes sexual intercourse through deceitful means or false promises to marry, punishable up to 10 years in prison and fine. Okay, so sexual intercourse in the name of marriage is actually a crime. It is actually punishable. And also, clause 103 recognizes murder on the ground of race, caste, or community as a separate offense. The next one is inclusion of organized crime and terror. So you have offenses such as organized crime and terrorism previously covered under specific laws of UAPA, that is Unlawful Activities Prevention Act, as well as state-specific laws are now included in the BNS. Moving forward, clause 111, clause 1 defines organized crime to include activities like kidnapping, extortion, cyber crimes with severe consequences are also included, and which also includes human trafficking. The next one is removal of sedition. Sedition has actually been removed and has been replaced with offenses that endanger the sovereignty, the unity, as well as integrity of India. That is, a proper definition has actually been given. The next one, community service. It introduces community service as an alternative form of punishment for certain offenses rather than being too very extreme. Okay, so that is why the new criminal laws are said to be reformative in nature rather than, being very, very parochial in nature. Next one is mob lynching. Okay, so this actually specifically recognizes and adds penalties for the mob lynching, reflecting a legislative response to the recent societal issues. So moving forward, let us now understand about what are the recent changes included in Bharatiya Nagrik Suraksha Sanhita. And here, extended police custody is there. This actually allows for extended detention in police custody up to 19 days for certain offences. And then the previous limit was only 15. The next one, trials in absentia. Okay, so this actually gives convictions even if the accused is not present. Earlier, if there is actually absentia, they would actually keep postponing the case. The next one is removal of statutory bail. Here, it eliminates the provision for statutory bail if an accused faces multiple charges, tightening the bail conditions. And the last one is victim-centric approaches. Here, there are tighter timelines for the completion of trials. Earlier, there was actually no upper bar on the time. But now there are tighter timelines for the completion of trials, and victims actually have the right to be heard before the withdrawal of cases with punishments of 7 years or more. And finally, if you see the changes that have been introduced in BSA, that is the Bharatiya Sakshya Adhiniyam, let us actually see there has been a recognition of electronic records as primary evidence. Earlier, the person has to be there in order to actually talk or give the evidence against the victim. But here, it has actually modernized the evidence law by treating digital records actually stored on electronic devices as the primary evidence. Moving on, there has been expansion of secondary evidence also. This includes oral and written admissions and also expert testimonies on document examinations. And finally, there has been admissibility of the electronic or digital records that we actually saw. Okay. So moving forward, let us see what is the significance of the new criminal laws, having discussed what is the need for it and looking at what are all the recent changes that have been introduced. Okay, significance is it's punitive versus reformative justice. I told you the new laws seek to move towards a reformative justice system by providing the community service instead of imprisonment. Whereas if you see punitive justice, it actually focuses on punishing the person who has actually committed the crime. The next one, there is modernization. The new laws actually replace the British era criminal laws with updated ones, aligning India's legal framework with the contemporary needs. And as the society evolves, they actually break down the stigma. And so this is actually channelized on that side. Next one, embracing technology, we know, right? That is, the new laws promote digitization and use of technology, facilitating streamlined and good criminal proceedings. Next one is decentralization of power. The new laws actually shift the focus of the government control now to citizen-centered criminal justice that actually emphasizes the swabhasha, that is the native language, the swadharma, that is the individual duty, as well as the swadesha, that is nationalism as well. Now let us understand what are the concerns with the new criminal laws. First one, there are actually concerns over extended, judicial or the police custody durations, which was earlier 15 days and now turned to 90 days. And also the broad definition of terrorism adopted from the UAPA could be actually misused because the government can actually use it in terms of its own favor. And the next one is there has been the hasty passage of all these three bills without adequate public consultation as well as discussion. This has raised concerns about transparency and responsiveness of the legislative process. The next article that we'll be discussing about is Court on Climate Right and how India can enforce it. So this particular article discusses about the recent Supreme Court judgment establishing a constitutional right to be free from the adverse effects of climate change or pollution and the other associated aspects, and it also discusses about how important and crucial is it for India to have a comprehensive climate legislation. Okay, so moving forward, here we'll be discussing about this particular concept of right against climate change as well as the fundamental rights, and this particular topic can be mapped to GS Paper 2 for the mains examination under fundamental rights and GS Paper 3 environmental pollution as well as degradation. So moving forward, there has been a previous year question in 2021 in the prelims examination with respect to that of right to privacy and which of the articles that it actually belonged to. So every fundamental right and the provisions and the subjects that actually belong over here is very, very important specifically for your prelims examination. Moving forward, now let us understand what this particular article is discussing about. Okay, so the Supreme Court recently ruled that the citizens possess a constitutional right to protection from the adverse effects of climate change. And now let us understand what was the judgment about. Okay, so in M.K. Ranjit Singh and ORS versus Union of India, that is 2024 case, the Supreme Court grounded the right in the fundamental principles of right to life, that is enshrined under Article 21 of the Constitution, and right to equality enshrined under Article 14 of the Constitution. The court also recognized that the government agencies definitely have a corresponding duty in order to safeguard the Indian citizens from the adverse impacts of climate change. Now moving forward, let us understand what is the background of this particular case. Okay, so in 2020, the environmental activists as well as the biodiversity conservationists, they actually came together and filed a petition with the Supreme Court in order to challenge the construction of overground power lines in Gujarat as well as Rajasthan that were posing a threat to this particular species of Great Indian Bustard. Okay, and following this, the Supreme Court appointed a committee in order to evaluate the feasibility of converting these overground power lines to underground lines and installation of bird diverters to prevent the bird casualties. Okay, and now what have been the key observations of the judgment that was actually given by the Supreme Court following this particular case was that first is right to life as enshrined under Article 21 of the Constitution. The Supreme Court had actually observed that the right to life containing within it, which is inclusive of the right to health, could not be fully realized without a clean environment that remains unimpacted by the climate change. Also, consequently, there existed a direct link between a deprivation of the right to life and adverse impacts of the climate change. Okay, so this is what the Supreme Court had spoken about right to life, within which this particular right to health is actually a part of it, which is not possible without a clean and healthy environment, that is without the impacts of climate change. Next one is right to equality, that is Article 14. The court also noted that food as well as potable water shortages would disproportionately affect the vulnerable groups and particularly severe on women and girls who often bear greater social and economic burdens during the environmental crisis. This is what the court had told. Now let us look into what are the other constitutional provisions related to this particular environment. Okay, so apart from Article 14 and 21, Article 48A of the Constitution provides that the state shall endeavour to protect and improve the environment and to safeguard the forest and wildlife of the country. This is nothing but it has to establish the concept of welfare state, and that was actually added as per the 42nd Constitutional Amendment Act of 1976, and this is a part of directive principles of state policy. The The next one is Clause G of Article 51A. This stipulates that it shall be the duty of every citizen of India in order to protect and improve the natural environment, including the forests, the lakes, the rivers and wildlife, and to have compassion for the living creatures. And this is actually enshrined under the fundamental duties. Now moving forward, let us understand what is the significance of this particular judgment. The first one is legal precedent for climate litigation. That is, by embedding the climate right within the constitutional rights, where it has actually said under right to live with dignity, right to health is also a part, the judgment sets a precedent for the future climate litigation in India. And this could lead to increased judicial intervention in ensuring the government compliance within the climate policies as well as actions. The next one is push for systemic climate governance. This is nothing but the judgment calls for more systematic governance around the climate change, urging the government to think through the possibility and enact the comprehensive legislation. That is what I actually said, that this speaks about what is a necessity for India in order to have a comprehensive legal as well as a climate legislation. Okay. Now moving forward, let us actually understand the intricacies which are associated with the judgment, whether it is actually very certain or not. First one, there is actually ambiguity in climate right enforcement. That is, this establishes a climate right. That is, the judgment actually talks about climate right, but it lacks clear guidelines for the enforcement, and this actually leads to varied interpretations and implementation challenges. The second one is legislative as well as policy gaps that is actually found in most of the legislations in India, and the interpretation of the judgments that have been given by the court are actually interpreted differently. Okay. So this actually highlights the need for comprehensive climate legislation, which may face legislative hurdles and also require extensive consultation. The next one is tailoring legislation to the Indian context. Okay, so here climate legislations must be tailored to India's specific context, addressing unique challenges and needs. And the last one is the factor of federalism. Okay, so climate law must balance the national action with that of the decentralized authority, resources and information to empower the states as well as local governments so that they can also build up the climate specific localized law instead of following a standardized law. The next article that we'll be discussing about is, should education be brought back to the state list? So as the title suggests, we'll be discussing about the debate or the recently ongoing debates whether this particular subject of education should be brought to the state list from its existing place in the concurrent list. Okay. So here it is important for us to understand what are the list under the 7th schedule of the Constitution, and this particular topic can be mapped to GS paper 2. Functions and responsibilities of the union and state governments and issues and challenges pertaining to the federal structure, devolution of powers and finances up to the local levels and challenges therein. Okay. So here basically center-state relations is actually the background topic. So here if you see in 2024, that is in the recent preliminary examination, there was a question asked on which one of the following statements is correct as per the Constitution of India, that is interstate trade and commerce, whether it is placed under the state list, and interstate migration, whether it is under the state list, and interstate quarantine is a union subject or under the union list. So these, kind of subjects which actually fall under the respective lists are very, very important, particularly for your prelims examination. Now moving forward, let us actually understand what this particular article is actually talking about. Okay, so the debate over whether education should be moved back to the state list from this particular concurrent list where both the union and the state can actually take a decision and legislate, but in times of a deadlock, the union will always prevail. So this has actually gained prominence due to various controversies, especially surrounding the national examinations like the NEET UG. Okay, for example, you have the NEET exam that is actually been proposed by the center, but there are states like Tamil Nadu which are actually opposing it. So in that, what happens? This particular debate has actually spurred up. So the historical shift of education from the state to the concurrent list had actually taken place during the period of emergency, and this has had long-lasting implications on the governance as well as the standardization of education policies in India. So moving forward, let us understand what are these union and the state as well as the concurrent list, and also let us actually substantiate each of that with the example. So, the 7th schedule of the Indian Constitution categorizes subjects under 3 lists. One is the Union list, where these are the subjects under the exclusive legislative power of the central government or the union government. Here, the subjects actually include the defense of India, the atomic energy, the foreign affairs, the railways and the infrastructure, post and telegraph, banking, currency, citizenship, interstate trade, commerce, aviation, etc. Moving on to the state list, the subjects that are actually included in the state list are under the exclusive legislative power of the state governments. Which are they? They include police, public health and sanitation, agriculture, prisons, local government, fisheries, markets and fairs, public order, entertainment taxes as well as state public services. And moving on to the concurrent list, they actually include subjects where both the union as well as the state governments can actually legislate. And in case of conflict, of course, the union law prevails over the other. And the examples of concurrent lists include the criminal law and procedure, marriage and divorce, bankruptcy and insolvency, trusts and trustees, education, forest, protection of wild animals and birds, trade unions, labor welfare as well as electricity. And if you see, these 3 lists are essential in maintaining a balance of power as well as responsibilities between the union as well as the state governments, ensuring both centralized and decentralized governance in India. Okay. So moving forward, let us actually quickly run through the historical background of how these particular lists actually emerged. So according to the Government of India Act of 1935, this actually created a federal structure of India which actually distributed the legislative powers between the federal and the provincial governments, that is between the center and the respected provinces. So education was initially a provincial, that is a state subject, and as per the 42nd Constitutional Amendment Act of 1976, based on the Swaran Singh Committee's recommendation, education was actually moved from the state list to the concurrent list in order to facilitate all India policies, or else you can say to bring a standardized policies toward the country. And the amendment lacked detailed rationale and was actually ratified without a significant debate or a healthy debate surrounding the same. Now moving on to the international practices or the global practices where they actually adopt, and what they adopt with respect to that of education is what we are going to see. With respect to that of the United States, we have the state and the local governments which actually set the educational standards, and they are the ones who actually mandates the standardized test and also supervise the higher education institution. Whereas you see the federal government, it focuses on the financial aid policies, the key educational issues as well as ensuring equal access to all its citizens. And if you see in case of Canada, education is actually managed entirely by the provincial governments, and in case of Germany, legislative powers for the education actually rests with the state. And here, if you actually look at a neutral way forward as well as the conclusion, so what are their arguments for the concurrent list is that the uniform education policy, that is in case of education is placed under the concurrent list, there is uniform education policy as well as improvement in the standards. And also there will be synergy between the center as well as the states for cohesive educational development. And if you see arguments for the state list, here the diverse nature of India, of course, requires tailored education policies. That is, it has to suit the local needs of different states. And also, the majority of educational expenditure, that is around 85%, is actually borne by the states, indicating their significant role in this particular sector of education. And also, centralization does not inherently resolve the issues such as corruption as well as lack of professionalism and the standard of education as well. And therefore, to conclude, what we'll say is, considering the significant role of the states in funding as well as managing education, a productive discussion and debate is actually required, and it has to come to the table on restoring education to the state list. The next one, this will actually allow the states in order to develop customized policies for syllabus, for testing, higher education admissions, etc. And also, central institutions can continue regulating higher education standards. The next article that we'll be discussing about is government approves 56 crore for the next phase of conservation plan for the Great Indian Bustard. So in this particular article, we'll be discussing about this particular species in news, that is the Great Indian Bustard, and also about the conservation efforts, and CITES is actually one such organization. And next one, this particular topic can be mapped to general issues on environment and ecology for the prelims examination, and for the mains examination, it is under GS paper 3, conservation of endangered species. Moving forward, there has been a previous year question asked in the prelims examination in 2020 regarding which one of the following protected areas is well known for the conservation of Indian swamp deer. So these kind of species in news and their conservation status, and they are conserved in which particular area or the national park or the biodiversity reserve, are all important for your prelims examination in particular. Now let us understand what this particular article is discussing about. Okay, so the Ministry of Environment, Forest and Climate Change has approved over rupees 56 crore for the next phase of conservation of the Great Indian Bustard. So this particular news is very, very important for the prelims examination. Now let us understand how are this conservation efforts are going to take place and what are the components. Okay, so this conservation plan actually aims to address various aspects such as the habitat development, the in situ conservation, the completion of the conservation breeding center, as well as releasing the captive bred birds. Okay. And also, the Wildlife Institute of India has proposed a detailed plan for scaling up the project for 2024 till 2023. And now, the conservation efforts actually has two components. The first one is completion of the Conservation Breeding Center, that is the CBC, in Jaisalmer's Ramderva, and preparation for releasing the captive birds, as we already saw, and implementing artificial insemination techniques. That is, here you actually inseminate the sperm into the female. Okay, and in human beings also it is actually done differently. That is where you inseminate into the uterus or the fallopian tubes of the woman. So here, this insemination is done to manage the genetic diversity as well as the fertility rate of the Great Indian Bustards. And the second component is in situ conservation of Great Indian Bustards in other states of Gujarat, Maharashtra, Karnataka, Andhra Pradesh and Madhya Pradesh with a budget of over 45 crores. Now moving forward, we already came across this particular discussion where we were discussing about Supreme Court's judgment on, a constitutional right to protect or to be free from the adverse impact of climate change, where we also discussed about the protection or the Supreme Court guidelines that was given in order to uninstall or to actually take care of the transmission lines in order to protect these species of Great Indian Bustard. So here the Supreme Court is overseeing the conservation program and had previously ordered burying of the overlying power transmission lines in the Great Indian Bustard habitat, and this particular decision was recalled due to practical concerns. Now moving forward, coming to the actual important topic, what are these Great Indian Bustards? So it is nothing but it is a large bird of the bustard family, one of the heaviest flying birds in the world, and it is actually the state bird of Rajasthan, very, very important. And the habitat is, they actually inhabit the dry grasslands and the scrublands of the Indian subcontinent, and its population is actually confined mostly to Rajasthan as well as Gujarat, and also small populations of them are found in states of Maharashtra, Karnataka as well as Andhra Pradesh. And they actually are undergoing recent threats in the form of collision or electrocution because of the lines, the power lines that are there, the transmission lines. And with power transmission lines, then because of hunting, habitat loss as well as alteration as a result of widespread agricultural expansion. Moving forward, looking at the protection status of this particular species, under the IUCN status, it is actually categorized as critically endangered, and followed by CITES, it is actually Appendix 1. CITES actually stands for Conservation and International Trade in Endangered Species of Wild Fauna as well as Flora. So this actually stands for CITES. And on CMS, that is Convention on Migratory Species, it is categorized under Appendix 1, as well as under WPA, it is under Schedule 1, and this is actually the image of the Great Indian Bustard. Now let us actually look at few of the conservation efforts by the government in order to protect this particular species of Great Indian Bustards. The first one is Project Great Indian Bustard. It has been launched by the Rajasthan government in order to construct the breeding enclosures for the species and developing infrastructure to reduce the human pressure on the habitats of these species. The second one is Conservation Breeding Facility, that is Ministry of Environment as well as Climate Change, and then Rajasthan Government and Wildlife Institute of India have also established a conservation breeding facility in the Desert National Park at Jaisalmer in June 2019. The next one is Species Recovery Program, where Great Indian Bustard has been identified for the conservation efforts under the component Species Recovery Program of the centrally sponsored scheme, that is Development of Wildlife Habitat. The next article that we'll be discussing about is BIS sends government debt warning before big global poll. So in this particular article, we will be discussing about the constant increasing of the global debts and this particular organization or the institution of BIS, that stands for Bank for International Settlements. And also this is actually very, very important, and we can map this particular topic to GS paper 1, that is globalization, and GS paper 2, international organizations as well, and also GS paper 3, economic growth and development. Okay. So moving forward, if you see in 2016, there has been a prelims question that was actually asked with respect to that of the new development bank. So these organizations, the institutions, their mandate, objectives, the founding members, particularly if India is a member or not, is very, very important for your prelims examination. Now moving forward, let us actually look into what this particular article is discussing about. So the BIS, that is the Bank for International Settlements, had actually cautioned that escalating government debt levels across the globe could actually destabilize the global financial markets. And also let us actually look at the current status of the rising global debt levels. Okay. So the global debt levels had actually hit a new record high of around $313 trillion as of 2023. And if you see, the global debt to GDP ratio has actually jumped to over 336% in 2021, the biggest surge of the debt. Okay, so 1 year debt surge since the World War II. And most of the rise in the global debt has actually come from the advanced economies that actually include the United States, the UK, Japan, as well as France. And if you see, the US federal government debt is actually on a rising trajectory that is actually estimated to potentially increase from just under 100% of the GDP today to over 170% in the next 30 years. Now moving forward, let us actually understand what this particular organization of BIS is. It is the world's oldest international financial institution that was established in 1930. And this was actually established out of the Hague Agreement of 1930 among Germany, Belgium, Italy, France, the United Kingdom, Japan, Switzerland, and the United States. So these member countries are very, very important. And its main role was to collect, administrate, and distribute the reparations that were imposed on the German government by the Treaty of Versailles after World War I. So what does this mean? So after World War I, Germany had actually lost, okay, against the powers of France as well as Britain. So what happened? It actually had to give away certain regions among French as well as the British government. Okay, so according to the Treaty of Versailles, they actually had to pay a lot of compensation and hefty amounts to these powers who actually rendered to be successful. So in order to manage all these things, what happened? The main role, and which organization was given the main role to administrate and distribute these reparations? It was this Bank for International Settlement. So here, if you actually look at this particular image, you can actually see that this acts as a bank for central banks. It is one of the oldest global financial institutions which was established, during this period of, the World War I. Next, operates under the guidance of international law and principal architect in the development of global financial market and headquartered in Basel, Switzerland. And moving forward, if we actually look at the objectives of this particular BIS, it serves as a bank for the member central banks, and its role is to foster international monetary and financial stability and financial cooperation. The headquarters, as we already saw, it is in Basel, Switzerland, and it actually operates representative offices in both Hong Kong as well as in the Mexico City. And moving forward, the membership is BIS is actually owned and governed by 63 central banks actually representing different countries that account to about 95% of the world's GDP. And in 2013, if you see, the Reserve Bank of India became a part of this particular Bank for International Settlement. Now moving forward, let us actually look into few of the functions of this particular institution. First, it is the lender of the last resort. That is, it offers liquidity, that is money, and financial services to the central banks for managing the foreign reserves. And next one, it is a banker to the central banks. That is, it also facilitates the international financial operations and also acts as a trustee to promote global financial stability. The next one, it actually, with respect to that of the research and statistics, it provides research and data on global banking and financial markets in order to aid the central banks in decision making. Now, how does this particular BIS operate? First one, both the individual as well as the central banks would subscribe to the shares that are issued by the BIS. However, the voting rights and the representation at the BIS meetings are limited to the central banks of countries in which the shares were officially subscribed. This is very, very important. Now, let us solve few prelims as well as the mains practice question. So, first question reads, consider the following statements regarding the 7th schedule of the Indian Constitution. Education is a subject under the state list and only state governments can legislate on it. No, this is wrong. Banking is a subject under the concurrent list where both union and the state governments can legislate. No, this is also wrong. Police is a subject under the union list and only the central government can legislate on it. This is also wrong. Since all the three statements are wrong, which of the statements given above is or are correct? Since all are wrong, D will be your answer. So, option D is your answer. The second question reads, consider the following statements with respect to that of CITES. So, CITES is a legally binding convention that all the parties should abide by. Yes, this is correct. It encompasses appendices 1, 2 and 3 that contain list of species that are given different levels of protection from over-exploitation. This is also correct. India is not a party to CITES. This is actually wrong. Since statements 1 and 2 are correct, your answer will be option B. Moving on to the third question, Supreme Court recently recognized the right to protection from the adverse effects of climate change as a constitutional right in which of the following cases? It is M.K. Rajit Singh versus Union of India. So, it's direct. So, the answer is option A. The fourth question reads, with reference to the newly introduced Bharatiya Nyaya Sanhita 2023, which of the following statements are not correct? So, here it introduces community service as an alternative form of punishment for certain offences. Yes, this is correct. It penalizes sexual intercourse through deceitful means of false promise to marry. This is also correct. It officially defines organized crime to include activities like kidnapping, extortion, cyber crimes, etc. with severe consequences and human trafficking. This is also correct. It strengthens the provisions related to sedition and adds more stringent punishment and penalties. This is actually wrong. Since option D is actually wrong, the answer will be option D. Moving forward, the fifth question reads, with reference to the Bank for International Settlements, consider the following. India is a founding member. No, this is wrong. It is headquartered in Basel, Switzerland. Yes, this is correct. And here both individuals and central banks can subscribe to the shares issued by BIS. This is also correct. Since statements 2 and 3 are correct, the answer will be option B. Now let us actually solve the mains practice question. The question reads, discuss the necessity for the reform in India's criminal justice system, highlighting the principal modifications introduced by the 3 new criminal laws and elucidate the concerns associated with these reforms. So, the approach answer for this particular question is actually divided into 3, that is broken down into the introduction, body and the conclusion. So, in the introduction, we will briefly outline the significance of replacing the colonial era laws like the IPC, the CRPC as well as the Indian Evidence Act with the Bharatiya Nyaya Sanhita, with the Bharatiya Nagrik Suraksha Sanhita as well as the Bharatiya Sakshya Adhiniyam, okay, in order to modernize India's criminal justice system. The next one, towards the body, we need to discuss about what is the need for reforms and what are the principal changes that have actually been introduced and in what way is it significant when compared to that of the previous criminal laws, and also the associated concerns shall actually be listed down. And also towards the conclusion, we need to emphasize on the need for safeguards to address the concerns and also ensure effective implementation of these reforms. So with this, we've actually come to the end of our daily news analysis. So for more such updates and for regular updates, please do like, share and subscribe to Narayana IAS Academy YouTube channel. Thank you and have a good day.